Hey everyone. I am back. I covered Candace Owens's motion to dismiss the Macron's lawsuit against her, and I had some people say to me, "Oh, no, she didn't file a motion to dismiss. She said she wasn't going to," and those people are absolutely right. We can look at that. Let's have a look at that.
I'm going to put an end to all the rumors, right? Because then you're gonna have to give me proof of this 30-year period where you just kind of.
So you're not going to try to have the case dismissed?
I certainly do not want to have the case dismissed.
Amazing!
Yeah,
I've never
so
heard that
we're having.
before.
I mean, we're having these discussions.
Guys, I just want to linger on this for a moment. Having been around a lot of lawsuits, I've never heard anybody sued. Particularly, they're spending a lot of money on this because Tom Clare and his wife have big expenses, and I think they charge a lot. I've never heard anybody say, I don't want a well-funded case against me to be dismissed.
So she did file a motion to dismiss. The Macrons actually then amended their lawsuit to add in further statements, no additional causes of action, just further statements that she had made since they filed the lawsuit. However, she then filed a motion to dismiss the amended complaint as well. So, there's that. So when she says she doesn't want to file a motion to dismiss, she's done it not once but twice. And that's important. I will highlight the inconsistency. When I read the motion to dismiss, I actually said, oh yeah, it's actually quite well argued. You know, I'm curious about what the Macrons respond with. And they responded with an absolute belter of a filing. But I did actually give props to Candace Owens's attorney. And I thought, okay, if I look at it this as at face value, they've done not a bad job. So now we can go to the Candace Owens, the Macron's opposition to her motion to dismiss, the one that she said she wouldn't be filing. Okay. So straight out the back, I seen this happen as well in the Lively and the Jones lawsuits against Wayfarer. Some of the filings where they start with a quote from the person, which completely contradicts their whole narrative. And I do love this. Okay, so they start out with a quote from Candace Owens. We'll get to the bottom of it, right? That's what discovery is for. We're going to ask a lot of questions. The Macrons are probably hoping, this will go away. And at least we'll say we sued her. We'll say we went after her. She'll probably file for this to get dismissed. But I'd like to make it to discovery. I think we owe that to the world. This is an opposition to a motion to dismiss. And if you're starting out with a quote from the person saying, I want to make it to discovery, I don't want to get this dismissed, then that's a pretty strong position to start. And it continues like this. Okay. Like the defamatory statements within the amended complaint, the words above are lies. Owens publicly vowed that she welcomed discovery and would not seek dismissal. Yet defendants now ask this court to do exactly what Owens told her audience she would never attempt. End the case before discovery even begins. And she is. That's exactly. There's no getting around this. There's no saying, oh yeah, but she wants it to come to Tennessee. She wants it to go to Tennessee because Tennessee has a much stronger anti-SLAPP, in my opinion, because Delaware actually has a really weak anti-SLAPP. It has recently changed, but the new changes, so it now has a much stronger anti-SLAPP law, but that only took effect after this lawsuit was filed. So, and it does not work retrospectively. It does not apply retrospectively. So, Candace Owens, if this case stays in Delaware, the anti-SLAPP law is absolutely not even worth having there. the one that will be applied to her case. If she gets it moved to Tennessee, she has a much stronger anti-SLAPP. Okay. And obviously, if she gets it moved to France, well, then the statute of limitations is only 3 months, and the lawsuit can't even proceed. Okay. So, I mean, either way, the alternatives she is seeking also get her out of this lawsuit. For nearly 2 years, defendants have promoted fabricated claims about plaintiffs President Emmanuel Macron and First Lady Brigitte Macron, including that Mrs. Macron was born a man, that the couple engages in incest, and that they participated in mind control experiments. They continued spreading these lies, even after plaintiffs provided evidence disproving them, to which Owens responded by taunting the Macrons and inviting them to file this lawsuit. Since then, defendants have again expanded their claims, most recently alleging that the Macrons were involved in Charlie Kirk's assassination and planned and financed Owens's assassination from the French-run hub of Wilmington, Delaware. Once they did, Owens pledged that she would not file a motion to dismiss so that the truth could come out in discovery. But now, after daring plaintiffs to sue and publicly promising to defend this case on the merits, defendants insist that the court dismiss the amended complaint on jurisdictional, procedural, statute of limitations, and forum non-convenience grounds. None of these arguments are availing. First, this court has personal jurisdiction over each defendant. Defendants do not contest jurisdiction over Candace Owens LLC or George Tom Inc., both Delaware entities through which Owens disseminated the statements at issue. Their only argument is that Owens supposedly lacks minimum contacts with Delaware, even though she deliberately formed and manages her businesses under Delaware law, conducts and monetizes her business through those entities, disseminated the defamatory statements into the state, and committed her tortious conduct through the Delaware businesses she controls. Since filing the motion to dismiss, Owens has only strengthened her Delaware ties by introducing new factual allegations in her podcast about purportedly relevant events in Wilmington and directing those claims to a Delaware audience. Due process does not shield defendants from jurisdiction where they have purposely availed themselves of Delaware's laws and protections to carry out their tortious conduct. Second, the amended complaint, which added factual detail but no new causes of action, was properly filed under Superior Court Rule 15a. Defendants do not challenge plaintiffs' ability to add jurisdictional allegations under Rule 15a. Instead, they assert that plaintiffs needed leave under Rule 15d because the amended complaint references additional statements Owens made after the original filing. But those allegations relate back to defendants' pre-suit actual malice, and even if Rule 15d applied, which it does not, the remedy would be granting leave to refile, not dismissal. Third, all the claims are timely. Defendants contend that Delaware's borrowing statute imports the French limitations period and bars the action, but the borrowing statute applies only when a plaintiff sues on a foreign cause of action and files in Delaware for no reason other than procedural advantage. That is not this case. The Macrons assert U.S. defamation claims against an American podcaster who created and published defamatory statements targeting a Delaware audience. Even if the borrowing statute applies, it does not. It would point to Tennessee's statute of limitations, under which the claims are also timely, not France's. Finally, defendants' forum non-convenience argument is both inconsistent and baseless. Defendants insist that Delaware, where Owens chose to organize her business and only 3 states from her Tennessee residence, is too inconvenient and that Tennessee would be preferable, while simultaneously arguing that the Macrons should have filed in France. Yeah, that was a head scratcher. That was such a bad argument. The contradiction is obvious and their position fails under every cryo-made factor regardless. Delaware is a proper and convenient forum, particularly for the Delaware entities through which the tortious conduct was carried out. For these reasons, defendants' motion, yet another attempt to avoid accountability for Owens's reckless, profit-driven defamation campaign, should be denied. So that was hitting the ground running. That was a good start. It keeps getting better. Defendants' smear campaign began in March 2024 when they seized on demonstrably false claims first floated by an amateur reporter and then amplified by a controversial investigative journalist. These fabrications gained momentum in France after a self-described clairvoyant broadcast them on YouTube. The Macrons immediately pushed back, including by filing actions in France against the original French authors who published these lies. Owens then brought these falsehoods to the United States and amplified them tenfold. Through her Delaware entities, she not only repeated but expanded upon the false claims, all without a shred of proof. The Macrons sent 2 detailed retraction demands documenting the truth. Mrs. Macron was born a woman. The Macrons did not commit identity theft, forgery, or fraud, and they are not in an incestuous relationship. Owens did not care. Rather than retract, she escalated, launching her 8-part Becoming Brigitte series, which further defamed the Macrons. She used the series, which reached millions, to layer on another baseless lie, that the Macrons participated in the MK Ultra or a similar mind control program. The Macrons made one final attempt to reason with Owens in July 2025. She again rejected the facts in favor of an even more fantastical narrative, and she profited from it, selling merchandise, subscriptions, and collecting donations premised on her defamatory claims. Left with no alternative, the Macrons filed suit on July 23, 2025. Owens began litigating publicly the moment she was served. That same day, she publicized her eagerness to depose the Macrons and obtain their documents and communications. She repeatedly told her audience that she was looking forward to the litigation, that she wanted this case to go all the way, and that she did not want to have the case dismissed. She again assured her viewers, "You can put me under oath, I will testify." She then began previewing her supposed legal strategy to drive donations. On August 14th, she discussed in a podcast episode who she hoped to subpoena, and on September 4th, she told her audience the litigation was going to get fun because she had the power of subpoena. Owens solicited and received increased donations by promising to see the case through and lamenting that her legal fees would cost her millions. Despite her promises, on September 12th, defendants moved to dismiss the original complaint. 2 weeks later, plaintiffs filed an amended complaint adding jurisdictional and factual allegations relating back to the original claims. Defendants filed the instant motion to dismiss, thereafter repeating many of the same arguments initially raised in their first motion. Where are we? Yeah. So, undeterred by this lawsuit, unfazed by the harm she is causing the plaintiffs, Owens has since escalated her attacks by making even more outlandish claims. She recently told listeners that the Macrons were involved in Charlie Kirk's assassination and used an aircraft hangar in Wilmington to carry out the same. She claimed that Kirk's assassination was orchestrated to distract Owens from exposing the plaintiffs and bizarrely even implicated her Delaware attorney's physical office space in the assassination plot. I haven't seen these episodes, but that just sounds nuts. That sounds completely outlandish. Defendants' relentless conduct makes clear that they will not stop publishing lies about plaintiffs and unless and until this litigation proves them false. For the reasons below, the court should deny the motion. Okay, argument. Defendants concede that this court has personal jurisdiction over Owens LLC and George Tom. Defendants do not contest personal jurisdiction over either of the business entity defendants, Owens LLC and George Tom, both of which Owens organized under the laws of this state. Nor could they. It's well established that a business entity is subject to general jurisdiction in the state in which it is organized. Therefore, even if this court were to determine that it lacks personal jurisdiction over Owens, which it should not, for all the reasons below, defendants concede that this case may continue against the remaining defendants on jurisdictional grounds. This court has personal jurisdiction over Owens. This court has specific jurisdiction over Owens, and consistent with due process, because Owens formed two entities under Delaware law solely to publish her podcast, social media posts, and other online statements, and this case arises directly from the conduct of Owens's corporate entities. Because her Delaware contacts are continuous, she routinely targets a Delaware audience, and she earns substantial revenue here. Owens is also subject to general jurisdiction, though the court need not reach that issue to maintain jurisdiction. Finally, Owens is subject to jurisdiction under Delaware law because she consented to jurisdiction arising from the business of her entities formed under Delaware law. At this stage, plaintiffs need only make a prima facie showing that Owens is subject to the court's jurisdiction, and the court must accept plaintiffs' unrebutted allegations as true and construe the record in their favor. Delaware courts, I've just spotted something, I'll get to it. Delaware courts recognize that personal jurisdiction in the online speech context is in its infancy, but are clear that jurisdiction is proper when the defendant's online commercial activity directed at the state is substantial enough to satisfy due process. And they cite Owens as, I don't know if you remember when I did my motion to dismiss. When I did Candace Owens's motion to dismiss, I actually said, well, hold on a minute. She's saying that this place is too inconvenient, it's going to cause hardship, but she has personally chosen to sue other companies there. She has been the plaintiff as both an individual and on behalf of her LLCs. And she has chosen Delaware as the forum to sue other companies. So she has actually utilized it herself. And I pointed out the kind of the hypocrisy of this. But the Macrons actually, they clearly know this because they have cited Owens's own lawsuit here. This is particularly so where, as here, Delaware has a strong interest in regulating its entities, overseeing those entities' managers and directors like Owens, and protecting its residents from in-state effects of tortious conduct. For the reasons below, plaintiffs have more than adequately pleaded facts justifying jurisdiction over Owens. If the court determines otherwise, plaintiffs request leave to serve jurisdictional discovery to uncover additional facts demonstrating Owens's contacts with Delaware. Okay. The court has jurisdiction over Owens under the long arm statute. The court has specific jurisdiction over Owens pursuant to the Delaware long arm statute and consistent with due process because Owens has not contested plaintiff's well-pleaded allegations. For this reason alone, the court should find it has specific jurisdiction over Owens. Regardless, plaintiffs have put forward sufficient facts to establish specific jurisdiction. And Owens, to the extent she responded at all, has mustered only conclusory allegations in support of her position. Under Section 3104C1, jurisdiction exists where a defendant transacts any business or performs any character of work or service in the state. Even a single transaction is sufficient if the claim originated from the asserted transaction. The ownership of a Delaware entity may constitute the transaction. Sorry, let me just go back. The ownership of a Delaware entity may constitute the transaction of business under Delaware's long-arm statute where the underlying cause of action arises from the creation and operation of the Delaware entity. Because forming a Delaware entity requires a filing in Delaware with the Secretary of State and not necessarily has an effect within Delaware, it is not surprising that Delaware courts have held consistently that forming a Delaware entity constitutes the transaction of business within Delaware that is sufficient to establish specific personal jurisdiction under 3104C1, when there is a nexus between the formation of the Delaware entity and the cause of action asserted in the lawsuit. Such is the case here. Owens formed two separate entities, Owens LLC and George Tom, for the purpose of managing her website, podcasts, social media pages, and other content that Owens drafts, researches, and publishes. Owens has admitted in legal filings that Owens LLC is a pass-through entity that is named after Owens and solely controlled and managed by her. Owens LLC operates and manages Owens's popular social media accounts, including the Facebook page. George Tom controls Owens's website, which hosts her podcast, sells her merchandise, links to her other social media accounts, sells subscriptions to her book club and Club Candace, and hosts a forum for visitors to post on a variety of topics. Owens admits that Owens LLC and George Tom are registered to do business in Delaware. Owens, through her entities, targets a Delaware audience, and Delaware residents listen to her podcast, subscribe to her website, follow her on social media, and purchase her merchandise. Owens, therefore, transacts business in Delaware. Owens created Owens LLC and George Tom to perform precisely the kind of activity that gave rise to this litigation, publishing political commentary and purported investigative journalism to a worldwide audience. Thus, forming Owens LLC and George Tom set in motion a series of events which form the basis for the cause of action before the court. Owens has even claimed in recent podcasts that French government officials have exerted undue influence under the governance of Delaware to inappropriately hold her liable to sue in this state. Owens does not dispute that Owens LLC and George Tom disseminate her products across the internet, or that Owens directed them to publish the defamatory statements at issue in Delaware. Thus, there is sufficient nexus between the formation of her business entities and the causes of action at issue to satisfy Delaware's long-arm statute. This court also has jurisdiction over Owens under Section 3104C3 because Owens caused a tortious injury in Delaware, and such injury was due to an act or omission by Owens in Delaware. Defamation occurs wherever the offending material is circulated. False statements of fact harm both the subject of the falsehood and the readers of the statement, and Delaware may rightly employ its libel laws to discourage the deception of its citizens. This is because the reputation of the libel victim may suffer harm even in a state in which he has hitherto been anonymous, or where the plaintiff's reputation was previously unaffected by the defamatory claims. Here, Delaware residents saw the defamatory statements and plaintiffs' reputations were harmed. Owens claims only that she has not taken any action targeting or seeking to serve the Delaware market, and that does not conduct business in Delaware. The court need not credit these conclusory statements, especially when weighed against plaintiffs' well-pleaded allegations and Owens' own claims in public court filings. Notably, Owens did not swear that she does not have a Delaware-based audience, that her website and social media pages are not visible in Delaware, or that she does not receive revenue from Delaware residents. That's good. That's good. The court has general jurisdiction over Owens under Section 3104C4. This court also has general jurisdiction over Owens. General jurisdiction exists when a non-resident regularly and continuously conducts business in Delaware. Section 3104C4 authorizes jurisdiction when a defendant 1. Regularly conducts or solicits business in Delaware, 2. Engages in a persistent course of conduct in Delaware, or 3. Derives substantial revenue from Delaware. Owens meets each prong both directly and as the principal of Owens LLC and George Tom. First, Owens regularly conducts or solicits business in Delaware. Through her business entities, she directed and oversaw the publication of the defamatory statements globally, including in Delaware. Her website, operated by George Tom, published the defamatory statements. Using platforms she operates through Owens LLC and George Tom, Owens published the same content on Meta platforms, Facebook and Instagram, YouTube, Spotify, iHeartRadio, and Amazon, all of which are Delaware entities. Her commercial presence in this state is intentional, continuous, and directed not only at consumers nationwide, but also at Delaware residents. Second, Owens engages in a persistent course of conduct in Delaware by contracting with Meta, YouTube, Spotify, iHeartRadio, and Amazon through her business entities, all of which are Delaware entities that operate extensively in the state. Owens also invoked Delaware's legal system when it suited her in the past, and this is what I brought up. This is the case I brought up. Including by asserting defamation claims under Delaware law. Her decision to organize and operate her business in Delaware, combined with her affirmative use of Delaware courts and laws, reflects persistent, deliberate conduct directed at this forum. Owens derives substantial revenue from Delaware. She and her Delaware entities monetize their content, including the statements at issue, by selling subscriptions to her content and merchandise to consumers nationwide, including those in Delaware. Owens does not dispute that she has paying subscribers and followers in this state. Her Delaware entities are the vehicles through which she distributes her product, i.e., her false claims, into every jurisdiction where they operate, including Delaware. Owens also derives significant revenue from her social media posts and podcasts, including through sponsored advertisements. A substantial amount of that revenue likely comes from Delaware consumers, further underscoring that she regularly conducts business here and is subject to general jurisdiction. Owens does not meaningfully dispute that she is subject to general jurisdiction under Section 3104C4. Instead, she argues that only that such jurisdiction does not comport with due process. Once again, Owens presents cursory assertions that she is not at home in Delaware because she does not own real estate in Delaware and she does not conduct business in Delaware. This ignores the fact that she formed two entities under Delaware law and that those entities operate Owens's website and social media and sell her merchandise, and that she registered them to do business in Delaware. And it ignores the substantial revenue she derived and continues to derive from Delaware consumers. Owens argues that a Delaware corporation maintaining a website that is accessible to anyone over the internet is insufficient to justify general jurisdiction. But Rotblat does not help Owens because the defendant was not even registered to do business in Delaware, and the only evidence supporting general jurisdiction was the defendant's website copyright and an affidavit that the defendant is a holding company. Plaintiffs have adduced significantly more evidence supporting general jurisdiction over Owens here. Owens' remaining arguments fail. She relies on SDF Funding LLC to argue that her formation of Delaware entities alone cannot establish general jurisdiction. But in SDF, the Chancery Court merely expressed reticence to base general jurisdiction solely on a defendant's formation of Delaware entities. Here, forming Delaware entities is just one piece of the jurisdictional puzzle under Section 3104C4. In addition to forming entities in the state, Owens has engaged in widespread multi-state commercial activity that has driven her products, her statements, subscriptions, and merchandise into Delaware. She has further subjected herself to this court's jurisdiction when it has suited her by bringing defamation claims under Delaware law and claiming that she suffered harm in the state through damage done to Owens LLC. These substantial deliberate contacts, far beyond the mere formation of a Delaware entity, confirm that jurisdiction over Owens is proper under Section 3104C4. Owens LLC and George Tom are Owens' agent and alter egos. Owens cannot evade jurisdiction by imposing the corporate form of Owens LLC and George Tom. Importantly, the long-arm statute recognizes that the forum-directed activity can be accomplished through an agent. Plaintiffs can also establish jurisdiction over an individual under an alter ego theory. Because both entities are the agents and alter egos of Owens individually, this court has jurisdiction. First, for jurisdictional purposes, plaintiffs can show that a defendant acted in the state through its agent if plaintiffs can show the defendant had dominion and control of the actor, or plaintiffs can provide evidence of the standard principal and agent relationship. In determining whether an agency relationship exists, Delaware courts consider the extent of overlap of officers and directors, methods of financing the division of responsibility for day-to-day management, and the process by which each corporation obtains its business. No one factor is either necessary or determinative. Rather, it is the specific combination of elements which is significant. Second, plaintiffs can satisfy the long arm by showing that an individual is the alter ego of a Delaware entity with significant contact with the state. This is appropriate when the plaintiff has shown that the corporation has no independent reason for existence and that its sole purpose is to provide a means for doing the act and bidding of the individual. Owens LLC and George Tom are agents of Owens, and Owens is also the alter ego of those entities. She is the sole manager, controlling member, and primary decision maker of both Delaware entities, which operate exclusively as the vehicles through which she creates, distributes, monetizes, and amplifies the defamatory statements at issue. Owens LLC is a pass-through entity solely controlled and managed by her, through which she directs and publishes all content on her Facebook and X accounts. George Tom likewise exists to operate CandiceOwens.com and disseminate her podcast, with Owens overseeing and directing all content that the corporation publishes. Because Owens conducts the very activities giving rise to this lawsuit through these Delaware entities, and because they are nothing more than extensions of herself, jurisdiction over her follows. Jurisdiction over Owens under the long-arm statute comports with due process. Exercising jurisdiction over Owens is consistent with due process. Due process is satisfied when a defendant has purposely established minimum contacts with Delaware and that the imposition of personal jurisdiction would comport with fair play and substantial justice principles. A defendant need not be physically within the forum. It is enough to create some substantial relationship with it. Due process is satisfied when a defendant has both purposefully directed its activities at residents of the forum state and the action arises from or is directly related to the defendant's actions within the forum state. When an entity intentionally reaches beyond its boundaries to conduct business with foreign residents, the exercise of specific jurisdiction is proper. Different results should not be reached simply because business is conducted over the internet. Jurisdiction over a defendant that disseminated defamatory statements nationwide, included into the forum state, comports with due process. Owens has intentionally conducted business in Delaware by offering her statements, subscriptions, and merchandise here and benefiting from related sales. Further, Delaware courts have consistently held that meaningful participation in the formation of the Delaware entity creates sufficient minimum contacts to satisfy due process. Owens has sufficient minimum contacts with Delaware because she deliberately formed, manages, and controls her Delaware corporate entities, and she used them to publish the defamatory statements within the state. She thereby purposely availed herself of the privilege of conducting activities within the forum state. Because Owens manages Delaware entities and derives substantial benefits from them, she should reasonably expect to be hailed into Delaware to answer for the tortious conduct she carried out through these entities. Plaintiff's claims relate to Owens's contacts with Delaware via her business entities and other Delaware businesses through which she published her defamatory claims. Fairness factors. 1. Delaware's interest in regulating its entities. George Tom and Owens LLC are Delaware entities, and Owens controls these entities. 2. Plaintiff's interest in obtaining convenient and effective relief. Delaware is plaintiff's choice of forum. And 3. Judicial efficiency. Dismissing Owens for lack of jurisdiction despite her significant contacts would result in 2 different proceedings in 2 separate forums about the same conduct, all weigh in favor of jurisdiction over Owens. The first factor, Delaware's interest in regulating its entities and those who manage them, weighs particularly heavily in favor of jurisdiction. Owens cannot plausibly claim unfair surprise after choosing Delaware law as the foundation for her business operations and using Delaware entities to publish the at-issue content. Dismissing Owens for lack of jurisdiction would lead to an unfair and inefficient result. Dismissing Owens individually while the case proceeds, as defendants concede it must, against the business entity defendants would be inefficient. This court has been hesitant to deny jurisdiction where doing so would lead to an unfair and inefficient result by requiring plaintiffs to pursue multiple causes of action in different jurisdictions, which would risk inconsistent results and the certainty of increased costs. Dismissing Owens individually from this lawsuit would require plaintiffs to refile identical claims against her personally in another forum, while this identical case proceeds here against the remaining defendants. The court should decline to force such a result simply because Owens's preference would be to litigate in Tennessee. The court has statutory jurisdiction over Owens under Delaware's manager and director consent statutes. This court has jurisdiction over Owens under section 18 to 109. Owens has consented to jurisdiction under section 18 through 109B because she is the sole manager of Owens LLC, a Delaware limited liability company, and the claims arise from Owens' action while managing that LLC. Section 18 through 109B permits a formally designated manager or anyone who participates materially in management to consent to Delaware jurisdiction by virtue of those roles. Owens is a formally designated manager who directs, controls, and participates materially in every aspect of Owens LLC operations. She used that managerial authority to publish the defamatory statements at issue, bringing her squarely within the statute. Thus, plaintiff's claims involve or relate to Owens' LLC's business as tort claims arising from its manager's conduct taken on its behalf. Contrary to Owens's argument, the consent statutes are not limited to disputes over internal affairs. Hazout plainly confirms that fiduciaries like Owens who use their corporate roles to commit torts are subject to jurisdiction for availing themselves of the protections of this state. The same reasoning applies to Section 18 through 109. Here, Owens used her entities to engage in tortious conduct. Therefore, the claims are related to her management of her Delaware entities, and she and the entities are independently liable for those actions. Owens argues that even if Section 18 through 109 applied to her, plaintiffs did not properly effectuate service under that statute because they did not serve a registered agent of the LLC. But Owens does not argue that she was not served. She was. That Owens LLC was not properly served. It was. Or that she was not notified of this action. In any event, any technical issue can be cured by permitting service under Section 18 through 109, not by dismissal. This court has jurisdiction over Owens under Section 3114. Likewise, Owens has consented to this court's jurisdiction under Section 3114 because she maintains control over George Tom, a Delaware corporation that disseminated the defamatory statements. Section 3114 permits jurisdiction in actions against the Delaware corporation where the individual is a necessary or proper party. Owens does not dispute that plaintiffs have pleaded a statutory basis for jurisdiction under Section 3114, nor could she. Owens is clearly a necessary and proper party. 1. She has a legal interest in the dispute distinct from George Tom's interest. And 2. The claims arise from the same set of facts and occurrences. Those criteria are met here. Owens's personal role in authoring and directing the publication of the statements gives her a direct and personal interest separate from George Tom's corporate interest, and the claims against her and the corporation arise from the same underlying conduct, the publication of the defamatory material through the corporation she manages. Exercising jurisdiction over Owens under Sections 18 through 109 and 3114 comports with due process. Like with the long arm, jurisdiction over Owens under either of these statutes is consistent with due process. Hazout makes clear that by becoming a director and officer of a Delaware corporation, a defendant purposely avails himself of certain duties and protections under our law. The same is true here. By electing to organize and run her companies under Delaware law, Owens accepted the benefits and responsibilities that accompany that choice, including the possibility of answering in Delaware courts for torts committed through those entities. As Hazout explains, such defendants cannot fairly say that they did not foresee that they would be subject to litigation in Delaware. Jurisdiction comports with due process, where a defendant purposely avails itself of the privilege of conducting activities within the forum state, and where the defendant should reasonably expect to answer for wrongdoing in that forum. Owens argues that plaintiffs cannot satisfy due process under Section 18 through 109, and therefore Section 18 through 109 cannot confer personal jurisdiction. Although the three-part test supplies one avenue for finding due process, it does not displace the minimum contacts analysis. Because Owens has minimum contacts with Delaware and jurisdiction would not offend traditional notions of fair play and substantial justice, no further analysis is necessary. Owens makes a conclusory statement that she lacks minimum contacts and the statutes therefore cannot confer jurisdiction over her in a manner consistent with due process. But the cases she cites prove the opposite. For example, in Ferradine Outdoors, the court found that by simply becoming a manager of a Delaware LLC, the counterclaimant purposely availed himself of certain Delaware duties and protections. Because the claims related to actions taken in his official capacity as manager of that LLC, jurisdiction was consistent with due process. The same is true here. Owens formed the LLC in Delaware to take advantage of the state's laws and protections. Owens is not only a manager of that Delaware LLC, she is the sole manager, further solidifying that the LLC operates as an extension of her. And plaintiff's claims relate to actions she took in that capacity, like causing the LLC to publish the defamatory statements. Owens then argues that when there is no affiliation between the forum and the underlying controversy, specific jurisdiction is lacking regardless of the extent of a defendant's unconnected activities in the state. But the claims here are surely affiliated with Delaware. Owens published her statements to Delaware residents through Delaware entities, and she has affirmed the affiliation between her defamatory claims and Delaware by describing purported evidence of plaintiff's wrongdoing, not only in Delaware but at her own attorney's office. Even if there was no prior affiliation between Delaware and the underlying controversy, Owens has created one through her own words. Because Owens intentionally availed herself of Delaware law by forming and managing Delaware entities, using those entities as the vehicles to publish and monetize her defamatory statements, contracting with Delaware-based companies to distribute her content, and causing reputational harm within Delaware, the exercise of jurisdiction fully comports with due process. Having chosen to invoke Delaware's legal and corporate protections, Owens could hardly have been surprised to be sued in this forum for misconduct she carried out through Delaware entities. Sorry, I'm just shutting the door. I can hear background noise. Okay. So far, so good. Quite impressed. This is very thorough. Okay. The amended complaint was properly filed. So as part of her motion to dismiss, Owens actually requested the second motion to dismiss, which would have been in response to the Macron's amended complaint. She actually requested that the court strike that amended complaint as well as dismiss the complaint. I didn't get to read the second amended complaint. No, I read the second amended complaint. I didn't get to read the second motion to dismiss, although it was almost identical apart from this request for the strike to the first one, which is the one I did read because that was the only one I could publicly gain access to. Okay. So, contrary to defendant's assertion, the amended complaint, which includes additional factual allegations relating to personal jurisdiction and defendant's actual malice at the time they published the defamatory statements, was properly filed. Defendants argue that the court should dismiss or strike the amended complaint because plaintiffs did not seek leave to file it under Delaware Superior Court Rule 15D. Specifically, they argue that the amended complaint, despite not asserting a single new cause of action, should have been filed as a supplemental pleading because it contains additional facts relating to statements Owens made after plaintiffs initiated this lawsuit. In doing so, defendants 1. Failed to address at all the additional jurisdictional allegations raised in the amended complaint. 2. Ignore or misunderstand Delaware Superior Court Rule 15A, which makes clear that a party may amend the party's pleading once as a matter of course at any time before a responsive pleading is served. And 3, failed to acknowledge that even if plaintiffs should have filed the amended complaint under Rule 15D, the appropriate remedy is to grant them leave to refile under that provision, not outright dismissal. Defendants concede that the additional jurisdictional allegations raised in the amended complaint are proper. Defendants argue that the court should strike the entire amended complaint because the additional factual allegations relate to statements Owens made after plaintiffs initiated this lawsuit. But notably absent from their motion is any mention of the additional jurisdictional allegations asserted in the amended complaint, all of which indisputably relate to pre-lawsuit occurrences. Defendants do not even acknowledge the additional jurisdictional allegations, let alone meaningfully argue that they relate to pre-complaint occurrences because they do not. To the extent this court is inclined to grant defendants' request to strike the amended complaint, it should decline to do so with respect to the additional jurisdictional allegations, which defendants do not argue are improper under Rule 15A, and grant plaintiffs leave to refile as described below. Plaintiffs properly filed the amended complaint under Rule 15A. The non-jurisdictional allegations raised in the amended complaint were also properly raised under Rule 15A. While Rule 15D provides a specific mechanism for pleadings based on transactions or occurrences that have happened since the date of the pleading sought to be supplemented, defendants cite no authorities to suggest that Rule 15D usurps rather than merely supplements Rule 15A's grant of an automatic amendment when no new causes of action are asserted. This is not surprising. Courts regularly consider circumstantial evidence such as transactions or occurrences that happened after the defamatory statements were made as indicative of actual malice. Okay. And that is all the non-jurisdictional allegations introduced. For instance, the amended complaint pleads that starting the day this lawsuit was filed, Owens consistently spoke about her state of mind at the time she made the defamatory statements. She stated that she said what she meant with respect to the defamatory statements, reiterated that she was telling the truth when she made the defamatory statements, despite Macron's claims to the contrary, admitted she was having fun doing bad things, and continued to showcase her hatred for the plaintiffs. She called the Macrons satanic, referred to them as her enemies, and peddled ridiculous conspiracies that Mrs. Macron was involved, as her brother Jean-Michel, in the Stanford prison experiment. Owens further reinforced her financial interest in spreading the false claims raised in the original complaint, which is clear-cut circumstantial evidence of actual malice. After this lawsuit was filed, Owens brazenly solicited donations to promote the series and fight this lawsuit, shared that it would cost millions for her defense team, released a second season of the series featuring paid advertisements, restocked her supply of and continued selling Man of the Year t-shirts, began selling #Free Emmanuel merchandise, and told listeners that the series had to become her life. Defendant's position would require plaintiffs to seek leave to amend simply to introduce additional factual allegations regarding the defendant's state of mind at the time they made the defamatory statement, even when, as here, no new causes of action were asserted. That is neither necessary nor efficient. Owens's persistent repetition of the claims at the center of this lawsuit is indicative of her state of mind, i.e., that she acted with actual malice at the time of publication. Plaintiffs properly raised additional factual allegations that post-date the initial complaint but relate entirely to pre-complaint issues under Rule 15a. The sole case defendants cite to support their argument, Pella Corp., does not dictate otherwise. In Pella, the court observed the overlap between Rules 15a and 15d, recognizing that the difference between an amended and supplemental complaint is often inconsequential, if not completely ignored. The only reason the court in Pella considered the distinction to be meaningful in those circumstances was that the revised pleading, which was styled as an amended complaint, brought an entirely new claim that had arisen since the filing of the original complaint. In comparison, all the amended complaint does here, aside from raising additional jurisdictional allegations, is provide more circumstantial evidence that Owens acted with actual malice at the time she published the statements. The Macrons do not, as defendants have acknowledged, bring any new claims arising out of transactions or occurrences that occurred after the original complaint was filed. They have merely raised additional circumstantial evidence to support defendants' state of mind at the time they published the defamatory statements. This is entirely permissible under Rule 15a. Plaintiffs properly asserted all the non-jurisdictional allegations raised in the amended complaint under Rule 15a. Plaintiffs' claims are timely. Plaintiffs' claims are well within Delaware's 2-year limitations period for defamation claims. Defendants' proposition that the claims are untimely because France's 3-month limitations period applies under Delaware's borrowing statute is absurd. Defendants misunderstand the purpose and effect of the borrowing statute, which simply does not apply. Even if it does apply, it would point to Tennessee's statute of limitations, under which the claims are also timely, not France's. The borrowing statute does not apply. The borrowing statute is designed to prevent forum shopping by plaintiffs whose causes of action arose under foreign substantive law but would be time barred if brought in that foreign forum. The party seeking to apply the borrowing statute must show that the foreign state's statute of limitations is so inseparably interwoven with the substantive laws at issues that the movement would have been deprived of their legal rights if the Delaware statute of limitations was applied. At its core, the borrowing statute seeks to prevent a windfall for plaintiffs whose claims are clearly governed by another state's laws, but would be time barred under that state's limitations period. In such a case, plaintiffs with remote ties to Delaware would be motivated to bring these foreign claims in this court solely to take advantage of a better limitations period. This is quintessential forum shopping. But that is not what is happening here. Plaintiffs assert defamation claims under United States defamation law against an American podcaster who has headquartered her businesses in this state and, as alleged in the amended complaint, has a significant following in Delaware. By defendants' own admission, the issues in this case are uniquely American. They call the mere filing of this lawsuit a violation of a sacred precept of the U.S. constitutional law, stress Owens' status as an independent American journalist whose rights have been staunchly protected under the First Amendment since the founding of this nation, claim that the initiation of this suit violates the First Amendment on its face, and argue that the additional allegations raised in the amended complaint cannot support a finding of actual malice, a uniquely American legal concept. There can be no serious claim that plaintiffs are solely motivated by forum shopping to avoid an unfavorable limitations period. Rather, plaintiffs have brought, as is their right, defamation claims under United States law against defendants with significant ties to the state and where it makes practical sense to litigate these issues. Defendants' own arguments demonstrate the absurdity of their position. In arguing for dismissal under forum nonconvenience, defendants contend that litigating in Delaware, 3 states away from Owens' Tennessee home, and where she chose to organize her companies would be unduly burdensome. But then in arguing for application of the borrowing statute, defendants assert that it would have been much more practical for plaintiffs to bring this suit in a French court, more than 4,000 miles away under the French limitations period. Defendants cannot have it both ways. They cannot argue that litigating in Delaware is prohibitively difficult and that it would have been favorable to litigate defamation claims made in the United States by an American podcaster with companies headquartered in Delaware and who hosts her podcast from her Tennessee home in any other country. Defendants simply do not want to be held accountable, even in the most practical forum for Owens's journalism. And I love how they put journalism in quotes. It's like they're being sarcastic. Even if the borrowing statute applies, it points to the Tennessee limitations period. Through this argument, defendants also invite an unnecessary and premature choice of law dispute. But even if this court concludes that the borrowing statute should be invoked, the claims are still timely because Tennessee's one-year statute of limitations would apply, not France's. Delaware courts will apply the limitations period of the forum in which the cause of action arose. If the court determines that the defamation claims did not arise in Delaware, the only possible alternative is Tennessee. U.S. courts have a long history of refusing to apply a foreign country's law in the context of speech-based claims, where, as here, the foreign jurisdiction does not have legal protections that are comparable to the First Amendment. And they do actually refer to the Depp Heard case as well. The reason they have cited Depp Heard, by the way, is they refused to recognize so obviously there was two lawsuits in Depp Heard. There was the first one in the UK where Amber Heard was not a defendant. She was not being sued. She was just a witness, subject to much less stringent discovery. So she could enter into evidence what she chose to. She could cherry pick her evidence. When you're a party, you don't get to do that. Also, the UK does not have the First Amendment. Our free speech. We have free speech in a sense, but it has more limitations than the US does. The US has free speech, and there are limitations, and defamation is one of those limitations. But they are much stronger free speech. We have stronger privacy laws. America has stronger free speech laws. And in Virginia, where the second lawsuit came, where Heard was a plaintiff, she could not rely on the UK ruling, which obviously was found in favor of the journalists. Now, there's a lot of controversy around that, which I'll do in a different video. But Johnny Depp did not win his case in the UK. He should have, but he did not. He did win his case in Virginia, but when Amber Heard tried to introduce the UK case, the judge was not having it because of the differences in the free speech laws. The UK does not have free speech laws that have the same level of protection as the UK, as America. So that's why that was. Okay, thus the borrowing statute, even if it applies in theory, could not borrow the law from France. Even if the court concluded that it was permitted to borrow the limitations period from France, the cause of action did not arise there. A defamation claim arises in the state whose substantive law is applicable to the claim. While a defamation claim may arise in the place of the plaintiff's residence, this is not the case where, with respect to the particular defamation, one of the other states has a more significant relationship to the occurrence and the parties. And this is especially not the case where, as here, the defamation claim is multi-state in nature. Whether a claim involves numerous forums is central to the choice of law analysis because the place of injury here, argued to be France by defendants solely because plaintiffs live there, will not play an important role in the selection of the state of applicable law. These factors, along with others, weigh strongly in favor of Tennessee over France. Owens is a Nashville resident. She records her podcast in the basement of her Nashville home. She made the defamatory statements while located in Nashville, and the impact of the defamatory statements was felt in Nashville as it was in Delaware, given her significant following there. Should the court determine that Delaware does not have the most significant relationship to this case, the claims remain indisputably timely under Tennessee law, the only viable alternative. And I do agree with that. Okay. Defendants should be denied the drastic relief of dismissal under the forum nonconvenience because they have not demonstrated overwhelming hardship. Even though most defendants are domiciled in Delaware, they still contend that the amended complaint should be dismissed on forum nonconvenience grounds. That most defendants are organized there, coupled with the activities directed at Delaware, effectively negate any claim of hardship. But by confusing their burden and misconstruing the cryo-made factors, defendants still argue that this case should be litigated in Tennessee. It is not. The court should defer to plaintiff's choice of forum and decline to dismiss the amended complaint on forum nonconvenience grounds. Defendants misstate their burden to prevail on forum nonconvenience grounds. Defendants attempt to lighten their burden by misstating the required showing for dismissal under forum nonconvenience. According to defendants, courts may decline jurisdiction over an action when litigating in the plaintiff's chosen forum would be inconvenient, expensive, or otherwise inappropriate. Not only that, they further argue that courts may dismiss a case merely because a more convenient forum has been identified. This is not the law. In reality, whether an alternative forum would be more convenient for litigation or perhaps a better location is irrelevant. Instead, to prevail under the forum nonconvenience doctrine, a defendant must meet the high burden of showing that the cryo-made factors weigh so heavily that the defendant will face overwhelming hardship if the lawsuit proceeds in Delaware. A defendant can only meet their burden by showing with peculiarity that the case is one of those rare cases where drastic relief of dismissal is warranted based on a strong showing that the burden of litigating in this forum is so severe as to result in manifest hardship. Defendants have not done so. Defendants cannot show the relevant factors weigh so heavily that they will face overwhelming hardship litigating in Delaware. Defendants cannot show that litigating in Delaware would cause them any difficulty, let alone a hardship so onerous to justify dismissal. The crux of the defendant's argument is that Tennessee is a more convenient forum for them, and that dismissal is warranted because some of the cryo-made factors weigh in their favor. But it does not matter whether only one of the cryo-made factors favor defendants or all of them do. The question is still whether the factors indicate that the defendants will suffer overwhelming hardship and inconvenience if forced to litigate in Delaware. None of the cryo-made factors justify dismissal. And this is where, in my opinion, her previous lawsuit, the choice that she made to litigate in Delaware, despite, never being resident there. She may have been living in California at the time she started the lawsuit. She subsequently moved to Tennessee before its conclusion. So I fail to see overwhelming hardship here. Relative ease of access to proof. Defendants contend that this factor favors dismissal because virtually all relevant evidence is located in foreign jurisdictions, thousands or at least hundreds of miles away. Defendants ignore that two defendants are organized under the state's laws, that Owens is in control of those Delaware entities, and that plaintiffs seek discovery, including publication metrics, from third parties organized under Delaware law, such as YouTube and Meta. It is not the case that virtually all the evidence is located elsewhere. To the extent evidence is located in France, it makes no meaningful difference whether this case is litigated in Delaware or Tennessee. And to the extent defendants suggest that the existence of evidence in Tennessee precludes their ability to litigate in Delaware, Owens's own discovery plans belie this argument. Owens has clearly stated that she intends to serve non-party discovery on individuals who do not live in Tennessee, including President Trump. Therefore, litigating in Tennessee will not reduce the need for interstate discovery. Ouch. Even if Owens may eventually encounter some inconvenience by proceeding in Delaware, the reality is that there is no one single forum that will be convenient for all parties and witnesses who are scattered throughout the globe. When looking at the relative ease of access to proof between Delaware and Tennessee, this factor is at most neutral, and in any event, any inconvenience suffered by the parties would be minimal, as modern methods of information transfer render concerns about transmission of documents virtually irrelevant. Given the location of evidence to be collected and the at most minimal inconvenience posed via interstate discovery, this factor does not weigh in favor of dismissal. Compulsory process for witnesses. Defendants identify a handful of potential witnesses they may offer and contend that because all of the non-party witnesses to this case live or work outside of Delaware, they are outside the jurisdiction of this court and cannot be compelled to attend trial here. This is not true. To start, many of the witnesses identified are employees of the Delaware business entities or Owens herself, who controls the business entity defendants. Those witnesses will undoubtedly be witnesses who are in control of the Delaware business entity defendants, and as such can be readily produced by them here in Delaware. Delaware has further adopted the Uniform Interstate Depositions and Discovery Act, which provides the necessary framework to compel third-party discovery from non-party defendants, including Owens's husband. Further, the use of technology, including video depositions, that can be taken wherever the non-party witness is located, strongly mitigates any inconvenience that may arise. Testimony from the witnesses who are beyond the range of a trial subpoena could be presented at trial by deposition, which has consistently been an adequate substitute for live testimony. Defendants cite one case, Beacor Timber, to support their position, but unlike in Beacor, defendants offer no detail as to what information those witnesses would testify to or why their testimony is necessary to begin with. Critically, defendants ignore that none of the witnesses in Beacor were identified as being under the defendant's control as employees, which is largely the case here. Even if the challenges posed by defendants did come to fruition, defendants have not shown that another forum, i.e. Tennessee, would provide a substantial improvement as to the number of witnesses who would be subject to compulsory process. Indeed, all the non-party witnesses who reside outside of Delaware would either be subject to testify as employees of Delaware entities or can be compelled to testify under Delaware's interstate discovery rules. To the extent defendants suggest that any yet to identified witnesses from France should need to testify, the compulsory process would be no easier in Tennessee than in Delaware. Even if this factor were to weigh in defendant's favour, it does so only slightly and does not come close to demonstrating an overwhelming hardship. View of premises. This factor carries little to no weight even in a case where there was a relevant premises that the fact finder might want to view. There are no premises to view in this case. This factor cannot possibly weigh in favour of dismissal. Dependence upon application of Delaware law. Okay, we haven't got much longer to go. I appreciate we've gone over an hour now by 15 minutes so far, but we've only got, I think, another 3 or 4 pages. Dependence under application of Delaware law. Defendants argue that this factor favours dismissal because Delaware substantive law plainly does not apply. This argument is both premature and wrong. Regardless, defendants' suggestion that this court could not effectively apply the substantive law of other states is absurd. This court is fully equipped to, and often does, interpret the laws of other states or foreign jurisdictions, including in defamation cases. Because this court is fully capable of interpreting another state's laws, even if it were determined that Delaware law does not apply, this factor is not indicative of an overwhelming hardship. Pendency or non-pendency of actions in another jurisdiction. Defendants argue that even though there is no related or similar case pending in another jurisdiction, this factor somehow still weighs in favour of dismissal. It does not. When no similar actions are pending elsewhere, the plaintiff's choice of forum is accorded even more weight. Whereas here, there is no other pending litigation. This factor weighs significantly against dismissal. In any event, because there is no similar action pending elsewhere, this factor weighs strongly in plaintiff's favour. Practicalities and efficiency. Lastly, defendants contend that numerous practical considerations also strongly favour dismissal. They argue that judicial resources should not be wasted on a dispute that has no meaningful connection to the state, and that Owens is not subject to personal jurisdiction in Delaware. But these arguments again ignore that Owens chose to establish her business entities in Delaware, and by doing so has availed defendants of the benefits of this state. This self-selected domicile has established Delaware as a jurisdiction for resolving any suits against them. Defendants further speculate that the court will dismiss Owens from this case for lack of personal jurisdiction, creating an additional significant and overwhelming hardship for defendants by forcing them to litigate overlapping issues in 2 separate fora, subject to potentially inconsistent rulings. Even if Owens was to be dismissed from the case, she should not be. The remaining defendants cannot premise their own dismissal on a hypothetical subsequent suit against Owens in another jurisdiction, let alone one that defendants are inviting to be brought by virtue of making this argument. In such a case, litigation should proceed against the business entity defendants. If Owens wishes to avoid duplicative litigation, she is welcome to withdraw her jurisdictional challenge. Defendants have not shown they will suffer any overwhelming hardship by litigating in Delaware, and their motion on forum non-convenience grounds should be denied. For the foregoing reasons, plaintiffs respectfully request that the court deny defendants' motions. Okay, so that's the response. That was quite lengthy. It was lengthier than Candace Owens's initial motion to dismiss. Very detailed. Great points. I'm curious to see how Candace Owens actually responds, but I thought that these were fantastic arguments. I do think, I have no love for Candace Owens, but I also have no love for the Macrons either. You know, it's not like I support either. I am just reading the lawsuit. However, I do feel that Candace Owens, whether she's right or wrong, she keeps saying things which then are going to be used to contradict her arguments. And the best thing she could have done, certainly at the point the lawsuit was filed, was just to stop and engage with the litigation, because she already had her series out and, you know, done what she wanted to do with it and got her story out, you know, and it was now at a point of litigation. So I don't know what's going to happen going forward, but there was great use of her own statements against her, great use of the law. I can't see it being dismissed unless Candace Owens' reply comes up with something, and she can't introduce new arguments to the original motion to dismiss. You can't use a reply to that for that. You can clarify some things or respond to things in the opposition. You cannot bring in new information or new points, because otherwise the Macrons would be allowed to potentially file a SIR reply to respond to that. But I'm really hard pressed to find an argument that Candace Owens can bring to overcome this. I think Delaware is certainly the right forum. That's my viewpoint. But it's like they said, the Macron said, you know, well, really, in reality, when it comes to convenience and factors, you know, getting witnesses, subpoenaing witnesses, sharing, you know, evidence and documents, you know, we have modern technology. We're able to do things remotely. And also, like, well, she's also said that they should have litigated in France. Well, how convenient is that going to make to, you know, to speak to subpoena witnesses? If there's an inconvenience from one American state to another American state, then how is the suggestion that they bring the suit in France helpful? And there is no one kind of place that is going to be entirely convenient for everyone, you know. And you know, the use of things like, you know, Candace Owens saying that she was going to subpoena Donald Trump. Well, he's not in France, he's not in Tennessee, and he's not in Delaware. So they're fighting her arguments with her own words. That is one of the strongest ways to push back in a lawsuit and defend a lawsuit. So I love it. I love that they cited her previous lawsuit as well. They didn't just say, oh, by the way, she has sued here before, you know, when it suited her, which they did say that, but they also they cited part of her case as well. That was quite good. That was really good. Really strong response. So yeah, we'll see on the 9th, I think it is. I will speak to Caryn. Again, if come check her out, she's really good, really lovely. But I will be back with Candace Owens's reply, and we'll see how she tackles these arguments. I may be surprised. I do keep a very open mind to that, but I'm very impressed with this filing. So I'm not going to hide that. I was quite impressed with Candace Owens's initial motion to dismiss, but now I've seen this response, I'm thinking, no, actually, this is much better. This is a much better, much stronger filing. So yeah, okay. Thank you for watching, guys. And I will be back on the 9th.